California Law, Employment Rights of Resident Apartment Managers, a presentation by Bob Benjy and Benjy Law Corporation. Disclaimers. This presentation is not intended as legal advice, nor is this presentation intended to establish any attorney-client relationship. Rather, this is merely an educational presentation intended as a general overview of the subject matter. If you believe you may have a claim, you are strongly encouraged to contact a qualified attorney for a consultation. Scope of this presentation. For purposes of brevity, this presentation is intended as a general overview of California employment law as it relates to resident apartment managers of 16 or more unit apartment buildings. The requirement of a resident manager. Every California apartment building with 16 or more units is legally required to have an on-site resident manager who lives at the property. See California Code of Regulations, Title 25, Section 42. The on-site manager is a W-2, non-exempt hourly wage employee of the landlord. She or he must be compensated based on the number of hours worked and may not be paid on a fixed salary. It is improper to legally classify the resident manager as a 1099 independent contractor. The requirement for a written, signed, voluntary contract. The law requires that all resident managers have a signed, voluntary, written employment contract with the landlord employer. This contract should specify all the particulars of the relationship, including its W-2 hourly wage nature. The contract should also specify the hourly rate of compensation, which at this time in California or in LA County is at least $15 an hour. The agreement should also discuss free or reduced rent and offset of wages earned by the manager against the manager's rental rate owed to the landlord for the manager's quarters. Industrial Welfare Commission Wage Order Number 5. The Industrial Welfare Commission Wage Order Number 5 concerning the public housekeeping industry provides the particulars of the law as they relate to the manager-landlord relationship. The order specifies, among other things, wage and hour rules and the rules for maximum allowable rent for the manager's quarters. Please like and subscribe. If you're getting value from this presentation, please click the like button, the thumbs up icon on this video, and also click the subscribe bell icon so you will be notified of our future video uploads. Doing so helps the YouTube algorithm cause this video to get wider circulation and distribution, helping us tremendously. Maximum allowable rent for the manager's quarters. Under Wage Order 5, where the on-site manager is required to reside at the property due to the 16-plus unit nature of the building, the landlord is prohibited from charging full rental rate of the manager for the manager's quarters. The law caps the maximum rent for that unit at a specified dollar amount, which amount depends on several factors. The factors include the number of employees the landlord has. 25 or fewer employees has one cap, 26 or greater employees has a different cap. The other factor that impacts the maximum allowable rent for the manager's quarter is the effective date we're considering for the analysis. Maximum allowable rental rates for manager quarters. Generally speaking, for landlord employers with 25 or fewer employees, the maximum rental rate the landlord may charge of the resident manager, effective January 1st, 2022, is just under $800 a month. For landlord employers with 26 or more employees, this rate is higher at nearly $850 a month. Note, however, that effective January 1st, 2023, regardless of the number of employees the landlord may have, the maximum rental rate for the manager quarter will increase to just under $850 a month across the board. Now a hypothetical analysis of maximum allowable rent. Assume a manager's quarters in the city of Los Angeles where rents are some of the highest in the nation. For example, assume a one-bedroom unit that would otherwise command a rent of $2,850 per month. Assume also that the analysis period is January of 2022. Regardless of what the unit is otherwise capable of commanding on the open market, the maximum rent that the landlord may charge the manager for that unit is capped at approximately $800 a month. Anything over and above that amount is a cost of doing business to the landlord. Offset of salary against the unit rent. In order for the landlord to legally offset salary owed to the manager against the rent owed to the landlord for the manager's quarters, it is imperative and legally required that the voluntary written employment contract so specify that this will occur and lay out the particulars. Otherwise, if the landlord unilaterally applies a debit of salary against rent owed without such an agreement, the manager could assert a wage and hour claim against the landlord for failure to pay minimum wage, notwithstanding the rent deduction actually having been applied. This could give rise to a multiple of wages owed, plus civil penalties, plus attorney's fees exposure to the landlord. What about landlord overcharging for the manager's quarters? Assume that the manager has agreed to a wage of $15 an hour and works 60 hours per month for a gross total salary of $900. Assume the manager is capped at a rental rate for the manager's quarters of roughly $800 a month. Where the landlord cheats and charges the manager $1,000 a month, the landlord is overcharging by roughly $200 a month. In this example, the landlord pays zero direct salary to the resident manager in violation of law, i.e. the landlord should be paying $100 a month in gross salary and offsetting the other $800 against the maximum rental rate allowed. This exposes the landlord to a wage and hour lawsuit for the $100 per month that went unpaid, including allowing for penalties and attorney's fees. In many cases, these attorney's fees will far eclipse the actual amount of the dollar dispute. What if there is no written employment contract? Continuing with our hypothetical, where there is no voluntary written employment contract as required by law, and the landlord nevertheless debits the manager's salary and applies it as a credit to the unit rent, the problem is further compounded for the landlord. Without the contract, the landlord is prohibited from debiting and crediting salary in this way at all. This scenario, even without overcharging for the manager's quarters, may give rise to a wage and hour lawsuit for failure to pay salary or failure to pay minimum wage. Again, this would expose the landlord to a multiple of back wages plus penalties plus attorney's fees. Landlord responsibilities. The law burdens the landlord to keep accurate records for the hours worked by the manager employee. Failure to keep these records could be used against the landlord if the manager later files a wage and hour claim, since it is the landlord's burden to maintain those records, not the employee's responsibility. Landlord employers are also required to furnish accurate, detailed pay stubs to the manager, including specification of gross pay, quantity of hours worked, rate of pay, exemptions, withholdings, etc. Maintain workers' compensation insurance, and pay employer payroll taxes. Reimbursement for out-of-pocket work expenses. Landlord employers are also required to fully reimburse manager employees for their out-of-pocket expenses in furtherance of their work. This includes, for example, a proportionate share of the manager's mobile phone expenses calculated based on an estimated percentage of time used. Of course, that assumes that the mobile phone of the manager is being used for work, but in many cases that is the case. At-will employment. California is an at-will state. This means that unless the landlord and manager have a detailed written contract otherwise specifying a term of employment, which is highly unusual in this context, the landlord may terminate the manager at any time with or without cause. Nevertheless, the landlord is legally prohibited from terminating the manager for any discriminatory reason, for example, based on sex, sexual orientation, race, creed, color, religion, etc., or is also prohibited from terminating the manager in retaliation for the manager asserting his or her legal rights, for example, demanding minimum wage, asking to be paid rightfully earned overtime or maximum capped rent, etc., or where the employee manager is cooperating with authorities or reporting a legal violation by the landlord, example, whistleblower protections. In any of those cases, any termination could be deemed to be improper and in violation of law. Statute of limitations. Where a resident manager has been underpaid or overcharged for the manager's quarters, or otherwise not received legally required reimbursements for out-of-pocket expenses incurred by her or him in furtherance of the job, or some other violation we discussed earlier, that employee may file a civil action to recover damages against the landlord employer. The statute of limitations for these actions, which is also the reachback period allowable by law, is generally 3 years prior to the filing of the action. This means that where the relationship has been ongoing for longer and where the wrongdoing has carried on for longer, the manager will be capped at no more than 3 years of damages only. Reminder to like and subscribe if you got some real value from this video and have not already clicked the like and subscribe buttons for this video, please consider doing it now. We greatly value and appreciate your support, and thank you in advance. Suspicious signs of potential landlord violations. Here's just a list of things to consider when determining whether or not you may have a claim. Any one of these may signal a potential landlord violation. Manager has no written employment contract. Landlord is charging the manager more than about $850 a month in rent for the manager's unit. Landlord is not furnishing regular detailed pay stubs to the manager. Landlord has the manager treated as a 1099 independent contractor. Landlord does not reimburse the manager for his or her out-of-pocket work-related expenses, for example, a portion of his or her mobile phone bill. Landlord pays the manager on a flat rate salary basis versus hourly. Landlord does not ask for or otherwise maintain detailed hourly records of all manager work performed. Any one of these is a red flag. Call Benjy Law Corporation for a free consultation. We offer a 1-hour legal consultation with an experienced attorney. This can be done either in person at our office in Beverly Hills, remotely via Zoom or FaceTime, or telephonically. The consultation is free of any obligation and completely confidential and protected from disclosure to third parties by the attorney-client privilege, even if we're not ultimately retained as your legal counsel. To make an appointment, please call us. We can be reached at 310-203-2650, or you can reach us by email at info@benjylaw.com. That's info at Benjy Law, spelled BENJY like yellow, law.com. This concludes this video. We hope you found it informative and useful.